H1B 100K fee under file in federal court. Hello everyone, I'm Muhammad Amir. I'm an immigration attorney and the founder of Amir Law Firm. If you have been following our channel, we recently covered the Presidential Proclamation that imposed a $100,000 supplemental fee on employers supporting new H1B workers entering the United States from abroad, a move that stunned businesses, universities, and healthcare institutions nationwide. Well, today we have a major update. The proclamation is now being challenged in federal court. Several organizations and individuals have filed a lawsuit against the administration, arguing that this 100K fee is unlawful and unconstitutional. Before I start, please make sure to subscribe to our channel and turn on notifications so you don't miss our new video and updates. Let's break down exactly what's happening, what the lawsuit claims, and how this could impact ongoing and future H1B filings. Recently, a collision of organizations and individuals filed a lawsuit in the U.S. District Court for the Northern District of California challenging this presidential proclamation. The plaintiffs alleges that this proclamation and the $100,000 fee are unlawful, unconstitutional, and procedurally invalid. In the complaint, the plaintiffs raised following four major arguments. Number one, the proclamation exceeds presidential authority. The lawsuit argues that the president does not have the power under INA to impose immigration fees or create new financial conditions for entry. Those powers rest exclusively with Congress. Number two, the proclamation violates the Administrative Procedure Act, APA. The lawsuit argues that the administration bypassed the required notice and comment rule-making process, issuing this sweeping policy overnight. For this very reason, even if an employer wants to pay this additional 100K fee at this time, there is no process available to pay this fee because agency may not impose a fee without following APA procedure. Number three, the proclamation is unconstitutional as it violates the separation of powers. The lawsuit argues that only Congress has the authority to appropriate funds and impose fees, not the executive branch. Number four, the proclamation is arbitrary and capricious. The lawsuit argues that the rule was rushed, unclear, and caused chaos for U.S. employers, recruiters, visa applicants, making it arbitrary under the APA's standard of judicial review. In this lawsuit, the plaintiffs are asking the court to block enforcement of the 100K fee immediately through injunctive relief, declare the proclamation unlawful, and require Department of Homeland Security and the Department of State to process H1B petitions under current law without the payment condition. If the court grants a temporary injunction, the proclamation could be paused, allowing new H1B entries to continue without the 100,000 fee while the case proceeds. That decision could come within weeks. As we discussed in our earlier videos, this proclamation applies only to new H1B workers abroad seeking entry after September 21, 2025. It does not apply to H1B extensions, amendments, or change of employers within the United States. Approved petitions filed before the effective date are current H1B visa holders with a valid visa. Still, the order has shaken the industries dependent on global talent, especially healthcare, education, or research, where employers rely on international professionals. Organizations have reported delayed start date, halted recruitment, and significant financial uncertainty, while agencies scramble to clarify implementation procedures. At this stage, here is what we recommend. Do not rush to file, but be ready to file new H1B applications for beneficiaries outside of the US until this case stabilizes. Continue filing extensions or amendments for workers already in the US. These remains unaffected. Track official updates from Department of Homeland Security, Department of State, and the USCIS. Guidance continue to evolve almost daily. If your organization has international hires pending, consult Immigration Counsel immediately before making travel or filing decisions. We will continue covering this case in our H1B update series and provide real-time updates as the litigation moves forward. For a full breakdown of the original proclamation and exemptions, watch our previous video link below. Make sure to subscribe to our channel, turn on notifications, and follow our updates. This situation is evolving day by day. Stay informed, stay tuned. As always, I will see you in the next video. Thank you.